Welcome friends, we have started this channel called Corporate Laws Galaxy. You know, galaxy means group of stars and every star represents different laws. And we are starting with a series on frequently asked questions on very interesting topics of corporate laws. And we are inviting you, all of you, to also send your queries in our comments column in our video, and we will certainly take up those queries also in our videos. And now I will request you to please share, like and subscribe to our channel. Thank you so much. Namaskar.
Sir, I have come across a frequently asked question from our professional colleagues regarding SEBI Prohibition of Insider Trading Regulations 2015, also popularly called as PIT regulations. Sir, whether creation of pledge, invocation of pledge and revocation of pledge can be deemed as trading under PIT regulations?
Very difficult question. But I will answer it.
Yes, sir.
You see, trading as defined under Regulation 2, Sub-Regulation 1 L of PIT means and includes subscribing, buying, selling, dealing or agreeing to subscribe, buy, sell, deal in any securities. You see, deal in any securities is the key word which is important. And trade shall be construed accordingly. The term trading is widely defined to include dealing in securities and intended to curb the activities based on unpublished price sensitive information, that is UPSI, which are strictly not buying, selling or subscribing, such as pledging, etc. So answer to your query comes here.
Yes.
Hence pledging, etc. is included in the term trading as per Regulation 2, Sub-Regulation 2 of PIT regulations.
Yes, sir. Very well understood. So, sir, at the time of trading, as per the trading plan, if the designated person is in possession of an UPSI which was not existing at the time of formulation or submission of trading plan, would these trades would be in violation of SEBI PIT regulations?
You are today asking very difficult questions, but very interesting.
Yes.
You see, if we refer to Regulation 4 and 5 of PIT regulations, it can be stated that an insider or designated person trades on the basis of earlier UPSI, unpublished price sensitive information, which is still not generally available, then it will be violation of SEBI PIT regulations. However, if at the time of formulation of trading plan there was no UPSI or later on a new UPSI was generated, then the trading can be carried out as per the trading plan, even if the new UPSI has not been made generally available.
Sure, sir. Very well understood. Moving on to the further, Regulation 7(2)(a) requires disclosure with respect to number of such securities acquired or disposed of within 2 working days of such transaction. If
You meant to say trading days?
yes, sir.
Okay.
If within 2 trading days of such transaction, if the traded value exceeds rupees 10 lakhs, in case of trades exceeding rupees 10 lakhs in a quarter, any subsequent trades need to be disclosed, or should the next disclosure be only when the next rupees 10 lakhs limit is breached?
Yeah, very tricky but interesting question.
Yes.
I'll answer it. No problem. The explanation to Regulation 2, Sub-Regulation B states that the disclosure of the incremental transaction after any disclosure under the sub-regulation shall be made when the transactions effected after the prior disclosure cross the threshold limit specified in clause A of sub-regulation 2. Hence, the next disclosure will be due when the next rupees 10 lakh limit is breached.
Okay, sir. Understood. So, sir, whether requirement of plea clearance is applicable for exercise of employee stock options?
Very good question. Employee stock option being issued under SEBI share-based employee benefits regulations 2014, the exercise of such stock options is covered under regulation 4.3b of Schedule B of SEBI PIT regulations 2015. Thus, no pre-clearance is required for exercise of such stock options. However, sale of share by employees obtained after exercise of such option shall not be covered under the aforesaid clause.
Okay, sir. Now we come to our last segment, that is adjudication of penalties under section 454 of Companies Act 2013. Sir, please tell us any latest case where Registrar of Companies has adjudicated penalty.
Yes, why not? Sure. You see, under the said section, Registrar of Companies is authorized to act as adjudicating authority to adjudicate penalty in case of violation of certain section of Companies Act 2013. You see, in the case of Strong Infraction Private Limited, Registrar of Companies, West Bengal, wide order dated 29th May 2013 imposed a penalty of rupees 3 lakhs on company and rupees 50,000 each on directors for violation of section 134 5A of Companies Act 2013, that is relating to provision regarding directors' responsibility statement referred to in section 134 3C of the said.
Thank you, sir, for giving such a clear idea.
Thank you, audience. We'll meet again. Bye.